Hello, and thank you for joining NCRPA. My name is Daryl Oakman. I'm the Executive Director, and today I will be walking you through the COVID-19 Tenant Relief Act, the new rental assistance program known as SB 91. The new law, SB 91, on Friday, January 29th, Senate Bill 91 was signed by Governor Newsom. With this passage, up to $2.6 billion in federal COVID relief funding will be used to pay landlords of certain qualifying low-income renters up to 80% of the rent owed due to COVID-19 financial hardships. Senate Bill 91 extends Assembly Bill 3088's eviction protections, which had an expiration date of January 31st, 2021. The new expiration date will be June 30th, 2021. Rental housing providers are not allowed to use security deposits or any rent payments to cover past due rent without written permission from their tenants. New forms. With the passage of Senate Bill 91, a series of new legal forms and notices are being made available to all NorCal Rental Property Association members in the Forms Library. A description of the new forms and compliance requirements will be presented later in this presentation. A summary of Senate Bill 91. The following is a summary of Senate Bill 91. The following information that will be discussed is not meant to be comprehensive. NCRPA encourages you to seek advice from a licensed attorney when making decisions about attempting to collect rental debt owed, or with respect to any other matter impacting your lease or relationship with your renters. For further information regarding evictions, please contact NCRPA's Eviction Department. Added extensions of SB 91. It extends transitional time periods from January 31st, 2021 to June 30th, 2021, which previously expired on January 31st of 2021 under Assembly Bill 3088. If a tenant or resident pays at least 25% of their rent due for each of the months from September 1st, 2020 to June 30th, 2021, and signs a declaration of COVID-19 financial hardship, they will be protected from eviction. The 25% must be paid on or before June 30th, 2021, and there is no obligation to make periodic monthly payments. The 25% may merely be paid as a lump sum at any time on or before June 30th, 2021. An extension of just cause protections. It requires all terminations of tenancies to be for just cause through June 30th, 2021. It extends expiration date of prohibitions on retaliation because COVID-19 rental debt from February 1st, 2021 to July 1st, 2021. Additional added extensions. Small claims court delays landlord access to small claims court for COVID-19 rental debt until August the 1st, 2021. Previously, it was March 1st, 2021 under the expired Bill 3088. Repayment of COVID-19 rental debt. The latest start date of repayment under a local moratorium has been changed from March 1st, 2021 to August 1st, 2021. Also, the latest end date of repayment under a local eviction moratorium has been changed from March 1st, 2022 to August the 1st, 2022. About the program, SB 91. SB 91 establishes a rental subsidy program. Rental assistance is to be paid directly to property owners. Each local housing agency or housing department will have a public-facing online portal through a community development financial institution. And the online portals are targeted to be available for online applications by March 15, 2021. Either rental property owners or renters may apply for this relief, and owners will be matched with their tenants or vice versa by the system. Relief covers past due rent for existing tenants, including any other financial obligations due under the lease, excluding damages to the rental unit. Program breakdowns. The rental assistance program will pay landlords up to 80% of the rent in arrears, not the total rent for that period. Between April 2020 and March 2021, and a landlord must agree to forgive or write off the remaining 20% and not pursue eviction for non-payment or any other curable breach of the lease. Alternatively, the program will pay landlords 25% of rent in arrears between April 1st, 2020 and June 30th, 2021. If landlords will not forgive unpaid amounts and forego eviction. Additionally, tenants may apply for payment 25% of the rent due for up to 3 months for the months of April, May, and June 2021. Under Senate Bill 91, if tenants pay 25% of the rent due between September 1st, 2020 and June 30th, 2021, and sign a declaration under penalty of perjury declaring COVID-19 financial related distress, the balance of the rent due, or 75%, is converted into consumer debt, and non-payment would constitute a basis for eviction. The rental assistance is to be made available for eligible tenants whose household income is no more than 80% of an area median income for the 2020 calendar year. Priority is to be given to tenants whose household incomes are no more than 50% of the AMI. Rental property owners would receive 80% of the total amount of rent in arrears covering the period from April 1st, 2020 through and including March 31st, 2021. Rental housing providers who accept 80% must agree to forgive the remaining 20% and not pursue evictions or seek to recover the remaining 20% of rental debt. This does not cover 80% of the total rent for the period, but 80% of the amount of rental debt that remains in arrears. In cases where housing providers do not wish to agree to forgive 20% of the unpaid rent, the state could pay 25% of the rent in arrears to provide renters protection from eviction. Tenants may also apply for assistance and receive 25% of the rental debt in arrears if the rental housing provider does not wish to receive the 80% program set forth above. To assist the tenant with reducing outstanding rental debt and to meet the 25% criteria necessary to be protected from eviction, the 25% would be made available to cover unpaid rent between September 1st, 2020 and March 31st, 2021. The assistance would be paid directly to the rental property owners. Additionally, a tenant can apply for and receive 25% of rent due for up to 3 months for the months of April, May, and June 2021, which assistance would be also paid directly to the rental property owner. Rental property owners would be required to notify their tenants of the availability of these funds. Rental housing providers that fail to notify renters of the availability of these funds under the rental assistance program would be precluded from proceeding with an unlawful detainer lawsuit. A new notification form Notice of COVID-19 Tenant Relief Act is available in NCRPA's Forms Library and is due on or before February 28, 2021. To any renter that as of February 1st, 2021, who owes rental debt covering the period of March 1st, 2020 through January 31st, 2021. What is now prohibited under SB 91? COVID-19 debt not allowed as a factor in tenant screening. Housing providers and tenant screening companies are now prohibited from using COVID-19 rental debt as a negative factor for the purpose of evaluating a prospective housing application or as the basis for refusing to rent a dwelling unit to otherwise qualified prospective tenant. Sale or assignment of COVID debt temporarily prohibited. The sale or assignment of COVID-19 rental debt is temporarily prohibited until July 1st, 2021. Additionally, the sale or assignment of COVID-19 rental debt for certain individuals who qualified for rental assistance, where the person's household income is at or below 80% of AMI for the 2020 calendar year. Increased fees, decreased services are prohibited. Increasing fees to a tenant or charging fees for services that were previously provided without charge is prohibited. Additionally, housing providers are prohibited from decreasing services or amenities. Security deposits. This prohibits landlords from applying a security deposit to a resident's COVID-19 rental debt during the tenancy without tenant's written consent, but permits application of deposit to COVID-19 rental debt after the tenancy terminates. Preemption and interaction with local laws. It prohibits extension or expansion of local eviction moratoria beyond what was in place on August 19th, 2020 until July 1st, 2021. Other provisions. It limits the maximum recoverable amount of attorney's fees on any unlawful detainer lawsuit seeking to recover COVID-19 rental debt. Charging of late fees in connection with COVID-19 rental debt are prohibited until June 30th, 2021. It prohibits any rental housing provider, tenant screening company, or other entity from evaluating prospective tenants on the basis that using COVID-19 rental debt as a negative factor. It prevents rental housing providers from applying current tenant payments retroactively to back rent or other charges. Making a good faith effort. Breach of contract actions to recover COVID-19 rental debt. A housing provider must make a good faith effort to seek available government assistance for the tenant and or cooperate with the tenant's efforts to obtain governmental rental assistance. A landlord must attach documentation of the foregoing to any complaint seeking payment of COVID-19 rental debt. This requirement, however, does not apply to certain jurisdictions that received a direct allocation of assistance under the Consolidated Appropriations Act. Failure by housing providers to make a good faith effort to seek available government rental assistance for the tenant and or cooperate with the tenant's efforts to obtain governmental assistance may adversely affect a housing provider's ability to evict or recover past due rent. In other words, a court may reduce the damages awarded if the court determines that a landlord refused to obtain rental assistance from the State Rental Assistance Program created under Senate Bill 91. In instances where the tenant has met the eligibility requirements and where where funding was available. The new form, COVID-19 Tenant Relief Act, Form F650. Notice of Information of COVID-19 Tenant Relief Act. This form has been updated, and this form is due no later than February 28th, 2021. Rental housing providers must, once again, serve a notice from the state of California to all tenants who have missed one or more rental payments. This new notice form must be served by January 28, 2021. For each month thereafter, if tenant does not pay all their rent due, rental housing providers should continue to serve the new 15-day notice for unpaid rent along with this new informational notice from the state of California. This notice must be provided to tenants who, as of February 1st, 2021, had not paid one or more rent payments between March 1st, 2020 and January 31st of 2021. And such rent amounts are still due and owing. This notice must be provided to all such tenants on or before February 28, 2021. In addition, this notice should be provided to tenants who do not pay rent due for any monthly periods between February 1st, 2021 and June 30th, 2021. If you fail to provide this notice to your tenants by February 28th, 2021, and thereafter, for each period a rental payment is missed through June 30th, 2021, you may not be able to evict your tenant or recover rent payments that are owed. How to serve the notice. Serving the notice of COVID-19 Tenant Relief Act. No other notices may be served to the tenant until the notice of COVID-19 Tenant Relief Act, Form F650, is served first and by itself. The notice of COVID-19 Relief Act may be served by mail only. If choosing this form of service, NCRPA strongly recommends serving this notice by regular first-class mail. Personal service of the notice is allowed. Service by posting and mailing the notice is allowed. Declaration of service of notice to tenant. You must fill out the declaration of service form immediately after you have served the notice of information of COVID-19 Tenant Relief Act form. The landlord or anyone at least 18 years of age can serve a notice on a resident. The person who served the notice is the person who should fill out and sign the declaration of service of notice to the tenant. It is suggested owners keep in their records a copy of this notice and a copy of the declaration of service as evidence of providing this notice. Without these documents, a landlord cannot proceed with an unlawful detainer. In conclusion, get your free copy of NCRPA's Form 650, Notice of Information of COVID-19 Tenant Relief Act, available on our website at www.norcalrpa, that's NORCALRPA.org. Serve all of your tenants the notice on or before February 28, 2021. Keep a copy of both the notice and the declaration of service for your records. Without it, you will not be able to evict them if it becomes necessary. Remember to make a good faith effort by either seeking available governmental rental assistance for the tenant and or cooperating with the tenant's efforts to obtain governmental rental assistance. NCRPA has provided SB 91 FAQs and is available for free download on our website. Thank you very much